Does an owner occupant of a single family residence who rents out no more than 2 rooms, bedrooms, accessory dwelling units, etc., have to put a written disclosure in their rental agreement saying that they're exempt from the Tenants Protection Act? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I had a colleague reach out to me with this exact situation right here. They have the landlord was given a letter by an organization, won't mention any names here to protect the innocent, indicating that their termination of tenancy was invalid because the owner did not disclose in writing in the rental agreement that they were exempt from the Tenants Protection Act. The scenario is this: owner lives at the residence. Okay, owner has a accessory dwelling unit in the backyard of her residence. It is her primary residence. Okay, she lives there. You know, that's the only place she calls home, pretty much. And basically, she built an ADU and basically rents out that ADU. Now, owner needs to terminate that tenancy. And some goobers that don't know the law basically sent a letter saying that, you know, the owner is violating the Tenants Protection Act. So here's the deal, folks. And this is from the Landlord Warrior. Okay. We don't usually do screen shares, but I'm actually just going to show you the law. Okay. Okay. But the exemption we're going to talk about here, single family owner occupied residence, including both of the following. Okay. The first one, there are 2 ways you can qualify. Okay. A residence where an owner occupant rents or leases no more than 2 units or bedrooms, including but not limited to any accessory dwelling unit or junior accessory dwelling unit or a mobile home. Okay. So guess what? There's no other condition in there. There's not a condition. You have to have a disclosure in your lease agreement or rental agreement that you're exempt from the Tenants Protection Act. That's not the text. Okay. Folks, when in doubt, you know, these non-lawyers or whoever, or even a lawyer tells you you have to have this, why don't you go read the law? Okay. Law is pretty straightforward. I'm going to tell you exactly why it doesn't work this way, because it's not in the plain text. If you go down to the only exemption that requires you to actually have a written disclosure is the one for subdivision E8, which is the one for single dwelling units. So single family homes. If you rent out entire single family home, that's where you're going to have conditions. Let's read the text. Okay. And let's copy all the following. The residential real property, including a mobile home that is alienable separate from the title of any other dwelling unit, providing that both of the following apply. Okay, those are conditions, folks. The owner is not a real estate investment trust, a corporation, a limited liability company, where at least one member is a corporation, management of a mobile home park. Okay. Let's scroll down some more. Second condition, the tenants have been provided written notice that the residential real property is exempt from this section using the following statement. And we've talked about this in the past, folks, about, you know, the property's not subject to the Tenants Protection Act. Okay. Subdivision E8, you have to meet the conditions. Okay. Because the law says you have to meet the conditions. Let's go back up to renting out rooms or having an owner occupied single family residence. Notice here, no such condition. Okay. Folks, if you're dealing with a situation where you're dealing with the Tenants Protection Act and you're dealing with someone that's saying you're not complying with the law or whatnot, it's probably best that you talk with an expert. We're here to help you out here. If you have any questions or comments, put them down below. You can reach out to us. If you're a landlord or property manager dealing with this exact situation, please feel free to reach out. Our contact information is down below. Until next time, folks, we'll see you then. Thanks.